Hi everyone, my name is Beth Brown and I am counsel in the pensions group at Mayer Brown. Welcome to this episode. In these episodes, we cover different topics each month, providing an overview of the issues faced by pension industry practitioners and offering some practical insight. The time spent listening to these episodes can count towards solicitors' continuing competence and PMI CPD requirements. All the episodes are available on our Mayer Brown YouTube channel, as well as iTunes, Google Play and Yahoo. You can also subscribe to this channel so that new episodes are shown automatically in your subscriptions feed. Hi everyone, Happy New Year! To kickstart 2022, in this episode I'm going to talk about the possible changes to automatic enrolment requirements. I will start off by summarising the current requirements as a refresher, because it has been nearly 10 years since automatic enrolment was introduced, and then I'll talk about the potential changes being proposed by a private member's bill. Before doing so though, I would just make the point that changes proposed by private members' bills do not usually become law, but in light of the renewed focus on automatic enrolment, such as the pensions regulator's blog encouraging employers not to neglect their automatic enrolment duties, it is possible that automatic enrolment could receive more attention during this coming year. You all know that since October 2012, employers have had to make arrangements for certain workers in the UK to be automatically enrolled into a pension scheme that satisfies certain conditions, that pension scheme being known as a qualifying scheme. Very broadly, workers fall into one of three categories. The first category is the eligible job holder, who must be automatically enrolled into a qualifying scheme and given a right to opt in. An eligible job holder is a worker who is aged between 22 and the state pension age, is working ordinarily in the UK, and has qualifying earnings that exceed the earnings trigger, which is currently set at £10,000. The second category is the non-eligible job holder, who must be given the right to opt into a qualifying scheme. If they use this right, then they are treated as eligible job holders for the purposes of employer contributions. So this means if a non-eligible job holder joins a qualifying scheme, the employer must pay the same minimum employer contributions on their behalf as it would do if the worker had originally been an eligible job holder. A non-eligible job holder is a worker who is working mainly in the UK, has qualifying earnings that exceed the lower qualifying earnings threshold, which is currently set at £6,240, and does not meet the criteria to be an eligible job holder, for example, maybe because they are aged under age 22. The third category is the entitled worker, who must be given the right to join a scheme, but it doesn't have to be a qualifying scheme. And then, even if they do join a scheme, the employer doesn't have to pay the same minimum employer contributions on their behalf. Although, in reality, for administrative simplicity, employers often do. An entitled worker is a worker who has earnings below the lower qualifying earnings threshold. So it's clear to see that the qualifying earnings threshold has a role to play in determining which group workers are in and how much money their employer pays into the pension scheme on their behalf. So I'll talk about that briefly now. Qualifying earnings are, in essence, the gross earnings payable to a worker over a period of 12 months, including various components of pay, such as salary and wages, commission, bonuses, overtime, and statutory maternity, paternity, adoption and sick pay. Qualifying earnings help, as I say, categorise workers and determine the contributions an employer has to pay. However, we all know that most contribution structures are based on pensionable earnings or pay rather than qualifying earnings. So employers can choose to satisfy alternative contribution requirements based on pensionable pay. Pensionable pay will vary from scheme to scheme and will be defined in the scheme rules, but typically it only includes basic pay, so it doesn't include the other elements that I mentioned are in qualifying earnings, such as overtime and bonuses. Now that I have explained the current automatic enrolment requirements, I will move on to the changes which are being proposed through a private member's bill. These changes are 1. To reduce the age at which automatic enrolment applies to all job holders from age 22 down to age 18, the idea being that this will allow younger workers to benefit from paying into a pension earlier and therefore build up a more meaningful retirement income. And the second change is the proposal to remove the lower qualifying earnings threshold for automatic enrolment, so that more people, typically low-income earners, part-time workers and multiple job holders, can join a pension scheme and start contributing to their retirement income from their first pound. Currently, a worker has to earn more than the earnings trigger of £10,000 a year in a job, and even then, their contributions are only required to be paid on earnings above the lower earnings threshold, which is currently set at £6,240 per year, and below the upper earnings threshold, which is currently set at £50,270 per year. Although, of course, there is nothing to stop employers paying more if they wanted to. It's suggested that this proposed change to remove the lower qualifying earnings threshold be introduced on a phased basis through freezing the automatic enrolment trigger and the qualifying earnings limit, and then eventually removing them completely in 2026. The intention behind both these changes is to allow an increased number of workers to join a pension scheme and for members of pension schemes to be able to save higher amounts of money so that more people have a more comfortable retirement. It's been argued that if these changes are introduced, a full-time worker on the national living wage would gain an extra £93,989 over a working lifetime, so nearly £94,000, which would be a 60% increase in their workplace pension saving. The private members' bill is due to have its second reading on the 25th of February, so time will tell whether these changes are indeed adopted. I would say watch this space. Thanks for listening. This episode is an overview of the law in this area, and how the law will apply in any particular case will depend on the individual circumstances. Please therefore remember to seek legal advice on your particular circumstances.